I am really happy to be having this discussion today. And today we're really going to be talking about what companies outside of the EU need an EU or even a UK representative. And I'm so thrilled to be joined by Tim Bell, who is the founder and managing director at DataRep. And it's my understanding that DataRep offers data protection representative services um, for companies who need an EU or a UK rep. So, Tim, thank you so much for joining me and for hopefully providing some clarification into this kind of complicated and uncharted territory.
Absolutely, and thank you, Sharon, for having me on the talk. This is really great for me to spread a bit of knowledge and share some information about the representative.
Excellent. So we know Article 27 of the GDPR requires companies outside of the EU or the UK to appoint an EU representative. I've worked with clients who are based out of Canada or the US and do business in the EU. They may not necessarily have an office in the EU. Some do, some don't. Some have employees scattered throughout the EU. So tell me and shed some light for us, who needs an EU representative? What companies need that?
Yes, absolutely. So as you say, GDPR Article 27 is the one which brings this obligation into force. And it's a requirement on any company which is impacted by GDPR as a non-European company. So it's companies which don't have an establishment within the EU. And establishment can be deemed quite wide. It doesn't necessarily need to be an incorporated subsidiary or an actual legal company within Europe, but it does need to really have a physical location to which requests can be posted and would be received. And if you're one of those companies, you're impacted by GDPR, that don't have an EU representative, that don't have an EU location, you are impacted by GDPR under Article 3.2. And as a result, you need to appoint a representative within the EU. And the representative really acts as the point of contact for the data subjects within the EU. It acts as the point of contact for the data protection authorities in the EU. So if any DSARs or any investigations, any requests for information come from either those individuals or the authorities, the EU representative would be their first port of call. And the representative also holds a copy of the Article 30 records of processing activities, which is essentially a document which is a high-level summary of the data protection activities, or the data processing activities, really, I should say, which a company is undertaking and the protections that are in place for those. And the representative holds that and makes it available to the authorities on their request.
So Tim, you talked about having an establishment in the EU. And that is where I always usually get stuck with what is considered an establishment. And I don't know if there's any case law out there or any opinion or guidance around what is an establishment. But if you have a company where they have employees, as I had mentioned before, scattered throughout the EU, there's no office. Is that considered an establishment? And then where would that establishment be? Would those employees, could they be an EU representative, or is that not sufficient?
It's a good question, and to be honest, there has been some guidance on this. Actually, recital 22 in the GDPR addresses the question to some degree, but really what it says is that you don't need to have that legal company, but they're pretty flexible. If you have a location which people can visit, which can receive post, it's likely that would be deemed to be an establishment. But having a number of employees, if they're working from home, for example, probably wouldn't give you an establishment. You could potentially label one of those employees as your representative, but to be honest, that individual it wouldn't be advisable for them, essentially, because the representative actually potentially accepts liability for their clients' unpaid GDPR fines. And as you know, when you're talking about a potential €20 million fine, the last thing that an individual wants to do is to accept responsibility if their employer is breaking those rules, probably outside of their visibility. So it's something which would usually be picked up by a specialist company because of the extra risks involved. And it's also worth noting that the representative shouldn't be the DPO as well. So if a company is appointing an external DPO, then they shouldn't also appoint that same company as the representative, because there's a potential for a conflict of interest there, because the DPO needs to have independence to raise their concerns with the company, whereas the representative is very much contractually driven and will follow their client's instructions.
That's some excellent advice. Tim, are there any exceptions for companies outside of the EU or UK where they don't need an EU representative, even though they may be engaging in business in the EU or UK?
Yes, absolutely. There's a couple of exemptions. Probably the most relevant ones are the public authority. So any publicly funded entities, so local governments, publicly funded healthcare, that type of thing, wouldn't need to have a representative, because they're deemed to have enough of an establishment, or at least enough of an official presence, that they're not likely to disappear anytime soon. I think that's the reasoning behind that exemption. And the other exemption, which is most commonly used, but I think also quite commonly misunderstood, is the occasional use exemption. And that says that if you're occasionally processing EU personal data, then you may not need to have a representative. But the way that's generally expected to be interpreted, and this hasn't been tried in court yet, so there's a degree of seeing which way it's going to go. But the way it's generally interpreted is that it needs to be processing which is an occasional type of process, rather than occasionally processing European data as part of a standard business process.
Can
So
you
to
give
give
us
you an example,
an example of what that is?
yeah, absolutely, because I appreciate that's quite a
Yeah.
distinction.
Yeah.
Imagine an e-retailer, so a North America-based e-retail company. Most of the clients are based in North America. Let's say they're selling ice hockey memorabilia. Most of the clients will be in North America, but they may have some clients perhaps in Europe who want to buy their goods. Although those individuals in the EU only represent a very small number of that company's client base, because they're processing the data in the same process as they do for their general customers as part of the sales process and mailing out the products that they're selling, that probably wouldn't fall under the occasional exemption, because even though it's a small number of people, they're doing so through a standard business process. Hopefully that helps.
Okay, so I mean, I can imagine that if I have a client and say 5 to 10% of their business is in the EU, and I'm going to tell them you need an EU rep because you're engaging in business within the EU, you're collecting EU data, they're going to probably roll their eyes at me and say, "Are you kidding? It's only 5% of our revenue, our total revenue." But what you're saying is it doesn't matter how small the revenue is or how much you're processing in terms of EU data. If you're processing EU data and you're processing it as part of your daily business activities, then you need an EU rep.
Yes, essentially. I mean, as with all European laws, there's a degree of proportionality, and if, I mean, to use it again, the ice hockey memorabilia seller, if they only ever have a single individual in Europe who they sell to, and they sell to them once, then I suspect that the European authorities would be willing to accept that they didn't have a representative. So there is a degree of proportionality there. It needs to be logical, but if you talk about percentages of business, 5% of a business can actually be a huge number of individuals. And so once you are starting to deal with a number of people, then it's certainly worth looking at appointing a representative.
Now, have there been any case law or any decisions around what happens to a company that doesn't have an EU rep that should have an EU rep?
Yes, and actually this was something which had been lacking for the first few years of GDPR's enforcement. But recently, the Dutch Data Protection Authority issued a €525,000 fine against a Canadian website, locatefamily.com.
Okay.
Yes, well, at the moment, to be honest, the case is somewhat in the process. Locatefamily.com is a very mysterious organisation. They don't have any details on the website, and the only reason that the EU authority, the Dutch authority, think that they're Canadian based is because of some work they've done behind the scenes looking at where the web domain is hosted. So there's still a bit of a question mark over that, to be honest. It appears to be North American, and they're pointing it towards Canada at the moment, but they don't know for certain. But this website effectively is a list of people. It's a list of people's names, their home addresses, their phone numbers, and it's notionally to help people locate family members who they may have lost touch with. But it's basically like a giant phone directory, and it appears that a lot of that information was added without the consent of the individuals. And clearly, under GDPR, that's a huge concern and potentially a violation. And also, it's quite difficult to have your information removed from that system. So, again, a breach of the GDPR rights. And a number of Dutch individuals had objected to this to the Dutch authority. And the Dutch authority had investigated and hadn't been able to actually find the company behind this website. But what they were able to show very easily was that they didn't have an establishment in the EU, but that they were processing EU personal data. So they were able to very easily establish effectively a strict liability obligation on that organisation to have a representative. It was clear that they didn't have a representative. And so they can say, right, it doesn't matter what company you are, where you're based, we're going to fine you. And they find within the usual Dutch instructions, their guidance for the level of fine. And so that 525,000 was actually an entirely reasonable, justifiable fine level for the Dutch authorities. Now, that may change a bit from EU country to EU country, but it sets at a very high level the precedent for bringing a fine against companies which don't have this representative.
That's very interesting, which actually brings me to another question that I have. You talked about this company collecting data within the Netherlands or in the surrounding area. Now, what if a company collects data, EU data, from various countries within the EU? So not just the Netherlands, it could be the Netherlands, it could be multiple regions. Where should their EU representative be established?
Yes, and this is one of the key points about the representative. The original GDPR text said that the representative should be in one of the countries where the processor has data subjects, but not necessarily any specific one, but just any of them. But then the European Data Protection Board issued guidance later, it's guidance 03/2018, where they confirmed that the representative really should be established in the country where the most data subjects are based, but also that the representative should be easily accessible for individuals in other EU countries where they're being processed. And so what it means is for many companies, they may actually need a representative which isn't just in a single country, but potentially in a few. Particularly if they have quite a wide geographical spread. And again, using the example of the e-retailer, they might have perhaps most of their clients in France or Germany, but they could have clients in Lithuania, Romania, Ireland, Portugal, Malta, any number of these countries. And having a representative which is solely based in, let's say, Ireland, wouldn't really be any particular use for an individual in Lithuania or Bulgaria. So actually, yes, really to meet in a fully compliant way the obligation, many companies would need to have a representative which has a number of locations.
So that's really interesting. So if you're going to your privacy policy on your website, I'm assuming that you're going to want to put the contact information of your EU rep on there. That was one of the purposes for getting an EU rep, so data subjects can actually contact that rep. So in the situation that you just described to us, if you have multiple reps in multiple jurisdictions, would you list the different reps within the different regions within your privacy policy?
Yes, absolutely. And the privacy policy is exactly the place you want to put it, because that's the place where the individuals will be going to find out how to exercise their rights. And yes, if you have representatives in different countries, you list them and you say, if you're based in the EU, please contact us via our representative. We have locations in Ireland and then their address, France their address, and each one, because or add a link maybe to a separate page if that's starting to make your privacy policy a bit unwieldy. Which, to be honest, I mean, one of the things there's been a drive for is to make privacy policies more readable. And if you have, you know, a huge list of addresses, that can sometimes work against that. But yes, if you have the access to that ability, then list them all. You know, it's helping your data subjects exercise their rights, but perhaps more importantly, it's evidencing your compliance with the GDPR obligations and showing the authorities, should they want to have a check, that you are meeting the obligations.
Tim, it doesn't matter if you're a controller or a processor when we're
No,
talking about the US.
no, absolutely. Both the processor and the controller have the same obligation to have a representative. Really, the only difference comes in respect of the number of requests which the representative is likely to receive, because a representative for a controller is likely to receive many more requests than the representative for a processor, for which really the request should be going to their controller client in the first instance. Doesn't always happen. So we will receive requests for our processor clients, send them on to our processor clients, and then they will have to say to the individual, actually, you need to speak to the controller first, and then they'll get this information from us. But by and large, individuals are going straight to the controller where that option is available.
Few other questions. If you have an EU representative, but you're doing business in the UK, do you also need a UK representative?
Yes, absolutely. So Brexit, as with so many things, has caused extra problems with the representative obligation. So a company which is, let's say, again, North America based, doesn't have any locations within Europe as a landmass, then they'd need an EU representative if they're selling into the EU, and they would also separately need to have a UK representative if they're selling into the UK. And this has created a lot of issues for many North American companies. For example, if they have a European office, it would have tended to be in the UK because of the convenience of the language, the time difference being at least closer. But those companies wouldn't have needed a representative before Brexit because their UK location would have counted as an EU establishment. But after Brexit, now they don't have an EU establishment because the UK office isn't in the EU, so they need an EU representative.
Interesting. Okay. My final question. We recently got the news that there are the new standard contractual clauses. This is kind of breaking news. Does it have any impact on EU representatives at all?
Yes, absolutely. And for those looking back on this from a historical context, the SECs were launched just last week for us as we record today. So to be, in all honesty, I haven't had the chance to go through them in detail. But one of the things that I did pick up from the review is that in clause 13, which has been changed since they were initially went out to consultation, in clause 13, it sets out a couple of optional paragraphs depending on whether the data importer is needs a representative or doesn't need a representative. So effectively, if they're exempt from the obligation to appoint a representative, and you would use different paragraphs in this clause 13 depending on the scenario. And so what that's going to mean is that the EU clients of US companies, particularly US processors, and that those EU companies are likely to be asking their US processors, do you need a representative, and if so, who are they? Because that's going to become part of that SEC contract. So it's going to be something which is much more in the thoughts of those European companies than maybe it was before. And so that's going to effectively, through a vendor procurement and due diligence process, likely to increase the take up of the representative.
I thought I also saw in Annex 1, you have to outline where the supervisory authorities are. And it's my understanding that they would be wherever your representative is. So that might also be a slight implication that if you don't have a representative, it's going to be pretty hard to identify which supervisory authority you have to report to.
Yes, absolutely. And as you say, it's the way that it's described in the SECs is put your European location or where your representative is in the EU. And if you have a representative who is in several different locations, then you need to pick a single one, and that should be the country where you have the most data subjects, at least at that time. You know, that can change, demographics shift within companies, but you go for the one that you think is the most, where you have the most data subjects, and list that as your head supervisory authority. There has been an argument in the past of foreign shopping, so maybe, you know, if you listed Malta as your lead supervisory authority, then perhaps you might escape the scrutiny that you would do if you listed France, for example, as the authority, who has a more a better funded data protection authority within France than Malta. But in truth, because of the one-stop shop mechanism that exists in GDPR, the French authority can just jump in and take
Oh,
control
really?
at any time should they decide that it actually is more relevant to them. So it's a bit of a non-starter. At best, it would slightly delay the issues, but potentially land you in more hot water on why you've made
Very
that choice.
interesting. Okay, that is amazing. I loved this conversation. I know I learned a ton. So Tim, thank you so much. But before we go, let us know, how does data rep help companies outside of the EU or UK in finding representatives or being the representative? Like, tell us a little bit about how you can help.
Yes, absolutely. So DataRep is an Irish company. It might sound surprising because I'm British myself, but it's Brexit reasoning. Essentially, it's hard to justify offering a European service from the UK these days. But with an Irish company, we have contact locations in all 27 EU member states, plus Norway and Iceland in the European Economic Area. And that means that, again, for this reason of where you have your representative, our clients are protected whatever happens. So even if they do have that big demographic shift in the middle of the year, and they've suddenly gone from having most people in France to having a big contract in Poland, they know that they have the representatives within those areas, so they're not going to find themselves out of compliance. We offer unlimited communications for our clients, so you don't need to worry about the number of requests you're receiving. It is subject to a reasonable use policy, but that's a very high limit, and we haven't seen that policy breached at any point so far. We provide quite large renewal discounts, and we price based on the risk in the data. So we look at the number of data subjects within the EU and whether you're processing the special category data like the medical or ethnic or religious, that type of data. And that helps us price appropriate to that risk. And so we have our smallest package starts at €150 for up to 1,000 data subjects, and that would be what you'd see that the small e-retailers and that type of thing taking up. Up to we do bespoke packages for clients with over 100 million data subjects in the EU. And also post-Brexit, we've set up a UK subsidiary which offers the UK representative role. So we can combine those two into a single package. So the companies that need both, effectively, they see the benefit of the volume discount from doing that both through us.
That is great. Seems like you're really providing a one-stop shop for everyone. Tim, thank you again for answering some of my questions. I know I learned a lot, and looking forward to hearing a little bit more as things develop, and hopefully we can have you back again and we can discuss it further.
Absolutely. No, it's been a pleasure, Sharon. Thank you very much for having me on.
So much, Tim. Take care.
Thanks very much. Goodbye.